And a very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for another program of The Law and You here on 4CRB. Your opportunity to get free legal advice between now and 9:30 or 10:30 Tweed Coast time. All we're asking you to do is give us a call. 55208888 is that number. 55208888. And speaking of south of the Tweed, well, certainly south of the Tweed River, don't forget you need to put 07 in front of the number if you're calling from below the Tweed River. Otherwise, Tweed heads north side of the river and through into Queensland, straight through on 55208888. And our first program in daylight saving time. We were expecting a quiet program last week because of the school holidays and a few other things, but it certainly was anything but a very, very busy program. I think we had about 8 calls, which fortunately we were able to take on air, which I'm always pleased about, because that not only gives me the opportunity to answer the queries that you have, but also the opportunity to help out other people who might be out there listening with a similar query but just are not in a position to get around to ringing, or alternatively hadn't really thought about the fact that we might be able to help them with an answer to their question. So thank you to all those people who called in last week. But that's enough of that. We're on the way already. As we say, a very good morning to Jack. G'day, Jack. How are you?
Yeah, good. John, is it?
Yes, it is. How can I help?
John, gifting, the word gifting money to you, I'm a grandparent, or the word loaning money or the word gifting money.
Right.
Regards to legal paperwork required, but also, John, where does one stand if it's an ongoing problem where they're always running out of money, if you know what I mean? You're always giving them something.
Right.
How can you write it off at the end of your life? Can you leave it in their will, or
yes.
in your will to give it? Just because the tax department sort of is out there waiting for everybody, I suppose.
Well, firstly, gifting money means that you're unconditionally giving the money to someone, and therefore, if you're gifting money to someone, what you could do is in your will to put it beyond doubt. At the end of the program, at the end of your life, in your will there could be a provision which says that I direct that any monies that I have given to any of my children during my lifetime, be it by way of gift or loan, is forgiven, and your lawyer would be able to give you the proper terminology for that. So that's pretty straightforward. Where you're loaning money, it becomes a little more complex, and it is certainly advisable to document loans in writing so that there is absolutely no question about the fact that it is a loan, and that there is an expectation that it be repaid. Now, if you subsequently decide that money that you've loaned is going to be forgiven on death, well, again, you would put a provision in your will saying that the money that I've loaned to my son, Bill, that's acknowledged by loan agreement, is forgiven, so that it's beyond doubt. One of the reasons why it would be advisable to document loans is because if, for example, a couple assist their one of their children and their partner or spouse in buying a house or something major like that, it is always advisable, if the intention is that is a loan and not a gift, to make sure that it is documented and signed by both parties, because if there's a split by the couple at some stage down the track and there is no documentation in place, you can bet London to a brick that one of the other party to the relationship is going to say, no, that was always a gift. There was never any intention that was only a loan. So, and if there is no documentation, well, clearly it becomes increasingly difficult to to argue that it was a loan rather than a gift. The other thing you need to be careful about with loans too is that that there is some form of acknowledgement of the debt every 6 years, so that the debt doesn't become statute barred, or you can get around that by putting a provision in it which says that this money is to be repaid on a particular date, and that date can be a long way out. But again, that's something on which you should be getting legal advice and making sure that any agreement is drawn up properly.
Oh, that sounds good, John, yeah. All right, just that it's got what is gifting here. I'm asking you, that even in the black and white Australian Government Human Resources, the word of gifting and terminology, because you're the one who's been dealing with it. But to forgive a loan, what is gifting? For example, if you or your partner forgive a loan. Now,
well, if you forgive a loan, that becomes a gift, because what you're doing is you're effectively saying, well, you no longer have any obligation to repay that money, so that becomes a gift. So it converts from being a loan into a gift, because you've said, I no longer require this money to be repaid, and therefore it changes in nature from a loan into a gift.
Yeah, so 6 years is a
that's the statute of limitations.
Statutory.
Yes. But
here, John, buy
but
a car for your daughter at present. What is a gift? Buy a car for your daughter as a present.
Well, if you buy a car for your daughter, that is a gift. I mean, if you're giving it to her as a present, if you loan her the money to buy the car and there's a clear understanding she's going to pay the money back, well, that's clearly a loan. But we'll have to leave it there, Jack. We've got other callers online. All the very best.
Cheerio.
Cheers now. Time on 4CRB is just coming up to 12 and a half minutes past 9. As we say, a very good morning to Paul. G'day, Paul. How are you today? Paul, are you there?
Oh, yes, John. How are you?
I'm well indeed. Thanks. How can I help you today?
Just ringing from my sister-in-law. She's been married 20 years to her husband, and second time around for both of them, and he's had 5 children, which are now adults by his first marriage, and they've both drawn up wills. He's living his lot to her, and she's living his lot to him. His 5 children, would they have any recall if he passes away? Would they have any recall on his estate?
If he passes away, yes, they do, because they come within the class of persons who would be entitled to bring a claim on his estate. But because your sister-in-law and husband have been married for 20 years, obviously that creates a far stronger claim for your sister-in-law as his spouse. The other thing they need to look at, though, Paul, is what is the nature of the assets they have. Have they maintained separate bank accounts? And is the home they live in, for example, in tenants in common rather than joint tenants, or have they effectively merged their assets so that their assets are jointly held?
Well, they both had separate bank accounts, but the home's in the joint name.
Okay, well, if the house is in joint tenants as opposed to tenants in common, then that property will automatically devolve upon the surviving joint owner, regardless of what their wills say. Do they live in Queensland or New South Wales?
Yes, Queensland.
Yep, okay. With bank accounts, if they have separate bank accounts, then the only thing that the children might possibly have a claim on would be on their father's bank account. But again, as I say, I think it probably unlikely that any claim would be successful. And if the amount is not significant, then the likelihood of a claim being mounted reduces, because obviously if there are 5 children and there's only 20 grand in the bank account, it's hardly going to be worth bringing a claim for $4,000 each. So there are practicalities that are involved. Does your sister-in-law have any children of her own?
Yes, she's got 3.
Okay, so the big issue for them is to work out what happens on the death of the survivor as to how the estate should be divided between his children and hers. So that would be the challenging point, which they're going to have to consider what they do.
I think the will's written up, if they both go at once, that the wills are split sort of 5 with him and 3 with her. So
Right,
They all
okay.
get a slice of the pie. But,
Okay.
she's a bit worried that she doesn't get on with any of his kids at all,
Right.
and she's worried that some of those are going to contest the will, and he's 88 and got dementia, and she's a bit worried that they might, come chasing her once he goes.
Well, what she
So
needs
they can take some of they can challenge the
they
money
certainly
in the
can
bank.
challenge the will, but the question is whether there would be any basis upon which they would successfully claim. And if your sister-in-law and so it's your brother, is it?
Yeah, it's my brother-in-law.
Your brother-in-law. Oh, sorry. So it's your sister that's married. Okay. So if their estate is only fairly modest, so I mean they don't have multi-million-dollar bank accounts, then as I say, I think the likelihood of a claim is extremely remote. But the thing that your sister should check is as to whether the house is in joint tenants or tenants in common. It very well may be in both names, so you can own a property in both names, but there are two ways of owning, either joint tenants or tenants in common. If you own as joint tenants, the property automatically goes to the surviving joint owner. If you own as tenants in common, the half of the house is dealt with under the will, but that becomes an asset that could be claimed against in the event of
I'm pretty
death.
sure, John, it's joint tenants.
Yeah, well, if that's the case, then she should be okay.
Yeah. All right, John.
All right,
thanks
then.
for your help.
Okay, then. All the very best. The time on 4CRB just coming up to 17 and a half minutes past 9, past 10 Tweed Coast time. The Law and You is the program, 55208888, the phone number. Don't leave those calls to the last 5 or 10 minutes of the program, where invariably we get a bank up. If you could get on that telephone right now if you have a question or a query, and we'd be happy to deal with it. We'll be back after this word from our sponsor.
Look forward to enjoying life your way with Halcyon, Australia's premier lifestyle community. Enter the Halcyon Do It Your Way competition for the chance to win your choice of either a caravan, gold bullion, or your dream holiday worth up to $50,000. Whichever you choose, do it your way with Halcyon. For entry details, terms and conditions, visit lifebeginsathalcyon.com.au. Ends November 30.
Our sponsor.
Harvey Norman, 12 days of big deals. 20% off HP laptops, desktops and all-in-ones. Higher 7.5 kilo front-load washer, only $449. Samsung 50-inch 4K UHD Smart TV, a red-hot $695. 60 months interest-free. No deposit, no interest with 60 equal monthly payments until September 2024. Minimum financed amount $1,000. Approved applicants only. Interest applies if you do not comply with terms and conditions. Fees and exclusions apply. Savings off normal ticketed prices. 12 days of big deals ends Monday at Harvey Norman.
Our sponsor.
And this is 4CRB. The Law and You is the program. 55208888 is that telephone number if you have a question or a query. Presently, we have no callers online, so if you want to get through, now is the time. 55208888. And while we're waiting for some callers, I heard some interesting comments by Steve Stuttle in a program, I think it was during the week last week, talking about the rapid approach of Christmas and the fact that we shouldn't be being concerned about the approach of Christmas. We should, in fact, be celebrating the fact that Christmas is fast approaching. And, of course, just a little reminder that today there's only 78 days until Christmas will arrive. So I can't believe how quickly that time is counting down. We say a very good morning to Trish, who's on the line. Good morning, Trish. How are you today? Trish, are you there? Trish, hello.
Good morning. My husband died, and I've got to do the will again, and I wanted to go to the public trustee. What would be against that? You know,
Nothing at all.
Oh, well, I was going past the other day, and they seem to be knocking it down.
Look, I wouldn't. Is this over in Southport? Is it?
Yeah. They moving or?
Well, they very well may be. I really don't know. But what you could probably do, Trish, would be to simply give their office a call, and I'm sure they will tell you whether they are going to where they are in alternative premises. I can't imagine that they would be wrapping up their service in Southport, because the Public Trust Office have been there for many, many years. But that being said, the property on which the Public Trust Office stands in Southport is prime redevelopment land, so that very well may be what's occurred. So what I would suggest you do is just look their number up in the phone book, give them a call, and I'm sure they'll be able to tell you where they are.
Thanks, John.
Okay then, Trish, all the very best. Time on 4CRB, just coming up to 21 minutes past 9, past 10, down on the Tweed. As we say, a very, very good morning to Carl. G'day, Carl. How are you today? Carl, are you there?
Yes.
How can I help you today?
I know you hit on those questions before about, is there any tax on gifts to your children?
No. The only exception to that would be if you're giving them things that may have a capital gains tax component to them. So if you're simply giving your children cash, then that is certainly not taxable. The one thing you need to be very careful of, though, is that if you're giving away cash, is not to fall foul of the Centrelink requirements that may affect your pension. I think from memory, you can give $10,000 a year and $30,000 over 5 years, I think, from memory, a maximum of $30,000 over 5 years. So you would need to, if you're going to give cash to your children, just double check those amounts and time limits with Centrelink. The other thing, though, is that if you were going to give one of your children a house, and it was an investment property that you had, and it was a post-September 85 asset, so in other words, you'd purchased it after capital gains tax came in, and it was an investment property rather than your principal place of residence, then there very well may be tax on that based on the gain, the increase in value between the date you acquired it and the date you gifted across to your child. The other one would be shares. If you were going to gift one of your children a parcel of shares, and again, you'd acquired them after September 1985, then that gift of those shares will in fact be a CGT event and would attract capital gains tax in relation to any increase in the value of those shares between the date you acquired them and the date that you gift them. If you gift property or shares that you owned prior to September 1985, then that very well may be tax-free. You would certainly, on the transfer of the property, you would still pay stamp duty. There would still be stamp duty payable. But you should check with your accountant before entering into any transaction where you're transferring a piece of real estate or publicly listed shares to make sure what the tax implications of doing that might be. And the other side of that, of course, is that if you were to gift a house and you're on the pension, you would probably lose your pension for a long time because the value of that house as a gift would affect your Centrelink entitlements, and you would probably lose your pension for many, many years into the future.
Oh, I was just thinking I'm on my own now, and I was thinking of downsizing in the house and getting something smaller.
Yep.
To be a surplus of money, and I was thinking of splitting that up between the children who are all adults, of course.
Yeah. Are you on the pension, Carl?
Yeah.
Yeah, well, definitely you need to be aware of that limitation on gifting. So I would strongly suggest that before you embark upon gifting any money that you speak to, there is a financial advisory service at Centrelink, and you can give them a call. You'll have to wait on the phone for a long time to get onto them, but the other side of that is that they do play some lovely classical music, so you'll be able to listen to a few concertos while you're waiting. But when you do get through, they are very, very good, and they would be able to walk you through what you're proposing to do and would be able to give you all the details of what's going to happen or what could potentially happen to your pension, etc., in the event that you embarked on the direction you're thinking of. All right, then?
As a single person, how much are you allowed to have in the bank before it affects your pension?
Oh, look, Carl, I'm not an expert on those figures. You'd be better to ring Finance Forum on Thursday. So ring at the same time on Thursday and they would be able to tell you straight away. But I just don't have those figures at my fingertips, I'm sorry.
Oh, thank you very much.
Okay, Carl. All the very best. Time on 4CRB, 25 and a half minutes past 9, past 10 on the Tweed as we say hello to Rod. G'day, Rod. How are you?
Oh, good morning. Thanks for taking my call. I just want to clarify what you were talking about before with respect to leaving a house to one of your children when you die. Now, pardon me. If we've owned the current house we're in, we've only been in since 2012, but we own it freehold. Even though it might be joint tenants or tenants in common, the whole thing will be that when both of us die, it will reverse, or the house will go to one of our children.
Yep.
Now, is that going to be regarded as a taxable thing for any taxation purposes that you know of?
If it's the house you live in as your principal place of residence and you've lived in it as your principal place of residence since you acquired it, then that is tax exempt. So your children, the property can be transferred to a child or children, and they inherit the cost base of the property as at the date of your death. So if they then subsequently sell the property in a few years' time, they will be taxed on the increase in value in the property between the date of your death and the date they ultimately sell.
Okay, that's interesting, because how are you going to, if that happens, how is it going to be determined that the value of the house, say, at 2021 and sold at 2024, how are they going to be able to determine those two separate values?
It's actually pretty easy to do, Rod. Valuers do it all the time. So I quite often have valuers provide a valuation of a property at some earlier date so that we can determine the capital gains tax implications of that transaction, and the taxation office generally accept that as a basis upon which that can be done.
Okay.
All right,
I think it's about all. Thank you very much for your time.
Okay, then. No trouble at all. Well, that probably is about all the time we have for calls today. I did have a couple of things to talk about, and perhaps one of those I can talk about very quickly, is the dangers of being an executor under a will, and Rod's call probably highlights that, in that the taxation affairs of the deceased can sometimes be quite complex, and people acting as executors need to be very careful to ensure that the tax affairs of the deceased are worked out correctly and finalised before they make a final distribution of the estate, because if a mistake is made and the tax office come and subsequently do an audit, I think the period from memory is 4 years from date of death. If they do an audit and find that there is an error, then the executor very well may not be able to get any money back from the beneficiaries, and could potentially be up for a tax bill. So just a little bit of a note of caution there, that if you are acting as executor, make sure you take seriously ensuring that all the tax affairs of the deceased have been resolved. This is John Fradgley from the Bell Legal Group. It's been great to be with you today for The Law and You. I'll look forward to being back, of course, next Tuesday for another program. But as always, until then, it's goodbye and God bless.